Yeah, hi, good morning, all. Is my voice is audible?
Yes, ma'am.
Yeah, okay, fine. Thank you. And hope my screen is also visible. Yeah,
Yes, ma'am.
fine. Yeah, thank you. Thank you all. Very good morning to everyone. So today we are going to see key labor law updates for the month of February 2026. So we have picked up few key updates and we are going to discuss in this session for the whole day. Sorry, in this session. And so before going in for this session, I would like to have a brief introduction about what related we do. See, our company is an ISO certified with more than 17 years of experience and with a client of over 200 and above clients. And we are we are providing service to about 16 cities and 5 countries. And to speak about our services, like we have handled employee records of over more than 1 lakh records in a month and 12 lakh transactions per quarter. All this happens with accuracy rate of 99.49%, and we have a client retention of 99.69%. So this is a brief introduction about what Relativity does. And a few clients to mention, enterprise clients, we have Toyota, we have Analog Devices, and we have MaxLinear. And in the mid-sized clients, we have Bavicle, we have Augusta, and Trumco. So what actually we provide consultation and services means it includes all payroll processing and compliance.
Excuse me, ma'am.
Yeah.
Ma'am, your voice is little bit lower, bit louder, ma'am.
Okay, fine. So, okay. Is it audible now?
It's audible,
Yeah.
but little louder.
Okay, fine. So what we do is like we are doing a payroll processing, labor law compliance and TDS compliance. And we do have a HRMS tool wherein we can manage onboarding right from onboarding to exit management. We have a compliance tool and we also do advisory services and consultation services in reference to HR and compliance audit also. Okay. So under payroll processing, we have, the payroll management, and we do consultation. And there is an employee self-service portal wherein the employee can post their details. And through that, we'll take the input and generate the payroll statement. And we do manage the reimbursement and expenses management also. And if required, we provide help desk services also in reference to payroll processing. Okay. So when we say payroll compliance, we file, we remit ESI, PF and labor welfare fund and PT remittance. And we also file the returns in reference to all these compliances. And with the support of a smart operator tool, we do this, the payroll compliance supporting activities like PF, ESI and labor welfare fund. Okay. And if required, we provide help desk services in catering this compliance services. So under tax compliance, we have Form 16 generation, and we validate the investment proof which is being submitted by the employees, and we ensure that the quarterly returns is being filed on time. And if required, we provide consultation for TDS and help desk activities also is being provided under tax compliance. So labor law compliance, all the labor laws across different region, we handle the labor compliance like maintaining registers, filing returns, periodic filings of returns. And in case if any inspection happens, we do handle the inspections and we reply to the inspection and close it as per the legal requirement. And if there is any requirement of registrations and amendment of those registrations, we do provide support services. We do offer this exact services which is required based on the location. So as I told you, we have this HRMS tool. It right from onboarding till exit, we have this can be managed through HRMS tool. So which includes leave management, attendance management, and payroll also. And even performance management also can be done with this HRMS tool. So we have a compliance tool wherein, see, for example, if any notice is being issued, so that you can, as an employee, you can keep track of this notices issued, where the notice, the status of the notice stands, like whether it is in the liaising process or it has been legally closed or not. And we do have an automated reminders also to manage these, what do you say, the statutory compliances. So, and we have a knowledge hub also, wherein the employees can easily access with the latest updates and amendments and keep ahead of the compliance. So, adding to that, we provide an exclusive services for POSH, Shop and Establishment Act and Apprenticeship Act. And right now, the current hot topic is on the Code on Wages consultation and the salary restructuring also. So, it is happening right away. And we provide service for digital data protection also. So apart from that, if we want any requirement regarding HR consultation or any advisory regarding that, we do provide service on that. So the most happening thing is the recent labor code changes. Okay, so that is happening. That is a current thing. So before starting the session, I would like to all the participants to have a participate in this poll. So you can see a few questions. It speaks about the employee size of your company. What is your department, which department you work with, and what is the nature of your organization, whether it is an IT, ITS, or other than IT, ITS, is it manufacturing, or if not manufacturing, any other sector, you can respond accordingly. Actually. So we have a size, establishment size, or we can say the organization size between 1 to 100 and 100 to 250 and 250 to 100 and 500 to 1000 and above 1000. And in reference to department, we have HR, payroll, and compliance. And regarding the nature of the industry, we have IT, ITS, manufacturing, and others. So I request all the participants to participate in this poll. Okay, so I'll just give an update on, like we have the company size between 1 to 100, we have 31%, and between 100 to 250, we have 22, and followed by 250 to 500. So 1000 above, we have 8%. And people from HR, I think they are the most who are participating in this session, about around 70% people I could see, followed by payroll and compliance. And we have a major portion from the manufacturing sector who are participating in this session, followed by IT and ITS. Divya, can we end this poll? Yes, thank you. Okay, so what is today's agenda? So we are going to see what are the key labor law updates which we had during the month of February 2026. And as an employer, what is the action you are supposed to, as an employee, we are supposed to take any actions as recommended by the notice or notifications, okay? And finally, we have a Q&A session wherein you can post your questions in the chat box. So introduction. So here, what are the key updates? Okay, for one is the code on wages. We have a notification which defines the definition of a worker, okay? And employee state insurance, under the employee state insurance, the Maharashtra government has given a notification which says about the coverage of ESI for educational and medical institutions. Okay? And the Kerala state government has issued a latest notification which gives about what is the revised fee for the registration or renewal of the registration certificate under the SHOP Act. Okay? And the Karnataka government, they have given the fee structure for the what is it, the aggregators, they have to pay for the welfare of the gig workers. And the under the same act, we have that insurance scheme. So wherein it speaks about how the gig workers, they can get themselves registered in the portal. Okay. And finally, we have the labor code. The Ministry of Labor and employment, they have issued a compliance handbook wherein the employees can have a very fair idea about, as an employer, what they have to do. Okay. Sorry for the disturbance. Okay, so code on wages, the government has notified an amendment in the definition of the worker. Okay, so the left side we can see that what is the definition as per the current existing, and the right side you can see the what is the amendment they have brought in. So when you say that what is the definition of worker means any person who is being employed in any industry to do any manual, unskilled, skilled, or technical or operational kind of job, or it can be a clerical or supervisory job also. So it says that even the supervisory job is also being defined under the definition of the worker. Okay, but this clause D speaks about, the subsequent clause speaks about who are all doesn't fall under the definition of the worker. So one such clause is the clause D, which speaks about the person who is being employed under the supervisory capacity, but who is drawing wage not exceeding 15,000 per month. Okay, so that is the current existing definition of the worker. Okay, so 15,000 is the limit. Okay, over and above the supervisor is drawing the 15,000 means he is not being defined as a worker. He will be considered as an employee. Okay, so right now the amendment has brought in which says that people who are in the supervisory job, but those who are drawing wages up to 18,000. Okay, earlier it was 15,000, but now it has been changed to 18,000 per month. Okay, so people who are drawing 18,000 who are in the supervisor category, who are drawing wages up to 18,000, they will be considered as a worker. Employee State Insurance Act 1948. So the Maharashtra government, they have given a notification stating that the ESI is very much applicable for all the educational institutions and the medical institutions. Okay, so when we say educational, it includes government, private, even the trust also. Okay, so all these educational institutions, they have to provide ESI benefits to all their eligible employees. Okay, and same goes for the medical institutions, the private and the government, and the even the diagnostic centers and the labs everywhere. Those employees who are drawing up to the threshold limit, they have to be provided with the ESI coverage right from the date of the notification. So this notification has come from the Maharashtra state government. Okay. So coming to the Kerala State Shop Act Amendment rules. Okay, so this notification speaks about the renewal fee structure. Okay, so they have revised the fee structure for renewing the registration certificate under the Kerala Shops and Commercial Establishment. Okay, so this table will provide you the details how the fee has been revised from the existing to the amended. Okay, so right from, if you have a head count which is nil, means you have to pay a fee of 70. Okay, so it goes up to above 100. So maximum fee is 5,250. Okay. So the Karnataka government, they have what they call as the Karnataka Platform-Based Gig Workers Social Security and Welfare Act. Okay. This act, the essence of the act is, or the objective of the act is to protect the rights of the gig workers. Okay. And it also provides the obligations from the aggregators, like what they have to do towards the social welfare or the social, or to provide the social security to the gig workers who are located in the Karnataka state. Okay. And moreover, if you have to avail any services through gig workers, there should be some transparency in what is the payout and what is the timeline, and these things which can be monitored through a website. Okay, so this act provides for this transparency in monitoring and decision making. Okay, and how much is the welfare fee an aggregator has to provide for each type of gig workers. So you can have a fair idea what is the fee for the each type of gig workers. And moreover, if this act provides for creating a welfare board wherein they support or they help us to resolve the gig workers dispute, any dispute if they have come across, it helps to resolve those dispute through this welfare board. Okay. So we need to understand few terms under this act. Okay, one is aggregator. So aggregator is a digital platform wherein it acts as a bridge between the buyer and the seller of the goods or services. Okay, it acts as a bridge between the buyer and the seller. So as per the definition of the act, it says that a digital intermediary that enables a buyer of the goods or a user of a service to connect with the seller of such goods or the service provider. Okay. It also includes any entity that coordinates with one or more aggregators for the purpose of providing such services. So not necessarily that one single aggregator is involved in catering any service or goods to the end user. Okay, it can be a multiple aggregators also. So when we have to have the product which has to be delivered to the end user, means not necessarily that one single aggregator is responsible to provide that service. Okay, a multiple aggregators can also be involved in catering this services to the end user. Okay, so payout means like whatever the payment that is being given to the the gig worker for providing these services. So that is called as payout. Okay, so this is more transparent, wherein we can have access through the website or the app, whichever we are availing through that services, or how much is the payment and the location details. Everything is being very transparent through that website or the platform. So platform, as I told you, it's acting as a bridge between the end user and the service provider. Okay, so this is like an automated monitoring, and it is possible through the different apps. Okay, like we have n number of e-marketing platforms, wherein once the end user, they avail the services or they place the order, they can keep track of their orders or the services. And this is a very transparent, wherein even how much is the cost that is being involved. Okay, so these are all this is being monitored, and it is being clubbed with the government portal also, actually. So how much is the, so essentially to understand how much is the welfare fee an aggregator has to pay. Okay, so this transaction is being clubbed with the government portal websites. So this is especially we are discussing for the Karnataka state government. Okay, so for each quarter, the aggregator has to collect, or they have to pay the welfare fee, and they have to submit the declaration in the website. Okay, so in a very prescribed format, they have given a prescribed format. Through that format, they have to pay the details of how much services they have offered for a particular quarter, and they have to calculate the welfare fee and pay it through the bank transfer. And this, what do you say, that this transaction is being mapped with a separate website, what they call as payment and welfare fee verification system. Okay, and this is being monitored by the government also. And this is how the payout structure means the welfare fee the aggregator has to pay for each gig workers. Okay, so if you could see the ride hailing services, so under that they have different types of what do you say, that categories, subcategories. One is two-wheeler service, three-wheeler, and four-wheeler service. Okay, and under the food and grocery delivery services, for two-wheeler 1% and a cap of rupee 50 paise. Okay, and for logistics services, there are different categories. You have two-wheeler, three-wheeler, light commercial vehicle, and heavy commercial vehicle. And accordingly, they have to remit the welfare fee to the Social Security Fund. Okay. And e-market services, you have two-wheeler, three-wheeler, and light commercial vehicle. So accordingly, the aggregator who are providing services to the end user as per the different types of category which is being mentioned here, they have to pay the welfare fee to the government. So this welfare fee will go to the social security benefits of the gig workers. Okay. So now we have a look at the insurance scheme which is being offered under the this act. Okay, so how the gig workers, to have this benefit, they have to get themselves registered in the specified portal. Okay, so what is the features of this insurance scheme? So this insurance scheme is applicable to all the gig workers who are located or who are offering services in the Karnataka location. Okay, so means whoever is working in this Karnataka location, they may come from different states. Okay, so that is irrelevant. Okay, so people who are operating inside the Karnataka, they are being offered this insurance scheme, and that too with a free of cost. Okay, so this benefit, the one thing which you can see is the benefit is very much available, or they can avail this benefit both for on-duty and off-duty accidents. Okay, so this is more beneficial for the gig workers. And moreover, to get themselves registered, they should have some eligibility also. They have to get themselves registered in the Seva Sindhu portal. To register that, there are few conditions which they have to meet out. Okay, so one is the age. Age should be between 18 to 60 years, and they should not be an income tax payer. Okay, and moreover, they should not avail any benefits with the current existing social benefits like PF and ESI. Okay. So whoever the gig worker, they either they can from the they can be a platform-based gig workers, or they can be from any unorganized sectors. They can get themselves registered under this Seva Sindhu portal. Okay, provided they fulfill all these eligible conditions. Okay, to get registered, there are few documents is required. They have to submit. So one is Aadhaar, and they have to have an identity card, or they can have a pay slip, or they can have a bank statement also. So all these documents are essential before getting registered in this Seva Sindhu portal. Fine. So we are going to see the compliance handbook that is being issued by the Ministry of Labor and Employment, especially for the employers for all complying under the all 4 labor codes. Okay. So here we can see all the compliance requirements for the code on wages, code on social security, code on occupational safety, health and working conditions, and code on industrial relations. So code on wages. So code on wages speaks about the minimum wages which the employer has to provide as per the government notification. So all the type of jobs, okay, whether it is skilled or unskilled or manual, whatever it may be, the appropriate state government will notify the minimum rate of wages. So the employer has to ensure that they comply with the minimum rate of wages as per the job category. Okay. And whatever the wage they pay, they have to adhere to the timelines that has to be specified by this act. Okay, so it can be daily, weekly, or fortnightly, or it can be monthly. So as per the recommendations or as per the compliance requirement, they have to adhere to these time norms, and they have to pay the wages accordingly. And once the employee leaves the organizations, how within how many days the final settlement has to be made, that is being recommended. And if you are recruiting male and female, or even the other genders also, equal opportunities should be given for all the genders. Okay, and even when we say equal opportunities, even the pay also should be equal. And it regulates the working hours and overtime also for the organization. Okay. So as an employer, okay, in reference to the payment of wages, what we have to do, okay, so as I told you, the minimum wage rate has to be adhered to as per the notification by the appropriate state government. Okay, so when the appropriate state government notifies the minimum wages, they have to ensure that they comply at least with the national floor wages. Okay, it should not be less than the national floor wages. So it is the responsibility of the state government that the minimum wage they set for each job categories, they have to either equal to the national floor or over and above the national floor wages. Okay, and there should not be any gender discrimination while recruiting any employees, or for any vacancies, or for any kind of positions. Okay, and the payment of the wages also should be very equal. So for daily, if it is a daily wage, means at the end of the day, the wages has to be paid. And if it is a weekly, means the last working day of the week is the final day for the payment. And if fortnightly, the payment is being made before the end of the second day of the fortnight, they have to pay the payment. Okay. And for monthly, it is on or before 7th date of the calendar month. Okay. And in case if the employee leave the organization, either it may be a voluntary or involuntary, or we can say that resignation or dismissal, or termination, what may be the reason, the payment of the wage dues should be within 2 days of the last working date. Okay, it should not be beyond 2 days. And working hours and overtime. Okay, so there is a fixed working hours with which the employer has to adhere to. Okay, so the normal working hours is 8 hours. Along with the rest interval, it is 9 hours. Okay, and the total spread over can be maximum 12 hours. So this spread over is varies according to the appropriate state government notification. So you have to check in for the state government notification for the total spread over hours. Okay, and the weekly working hours should be 48 hours and not beyond 48 hours. If it goes beyond 48 hours, it is considered as a overtime. Okay, so accordingly, double the rate of wages has to be paid to the workers. Okay. There are few registers and records which an employer is supposed to maintain under this code. One is attendance register cum muster rule, and the wage register, overtime registers, and register of fines and deductions. Okay, so these registers can be maintained either manually or it can be digitally also. Okay, so it is as per the convenience of the employer. This can be either maintained either manual maintenance of the register, or it can be digitally, we can maintain the registers. Okay. So once it is being maintained, they can retain the record for a period of at least 5 years period. Okay. So they should maintain the record retention period is 5 years. So there are few displays under this code. We can see the list of displays where the employer has to mandatorily display at the work premises. Okay. And moreover, they are specifically, the code specifically mentions that the language for these displays should be English, and in the language majority of the employees or the workers they know. Okay. For example, if you take Karnataka, the display should be in English and in Kannada. Okay. And in some cases, if there are majority of the employees, they are from the Hindi belt, means the Hindi language also must be used for the display. Okay. So what type of display you have to have means, one is the minimum rate of wages. Okay. So what type of job categories that is being engaged in that particular establishment, we have to make note of it. And what is the minimum rate of wages for all those jobs, that has to be displayed. Okay. And what is the normal working hours and the wage period, the date, I mean, whether it is a daily wage or it is a weekly or it is a monthly. Okay, that has to be mentioned. And what is the date of wage payment, that has to be specifically mentioned. And finally, the name and address of the inspector of that specific jurisdiction, that has to be kept on display. So here, this wage code, they provide for authorized deductions with which, I mean, the employer can deduct from the wage of the worker or the employee. Okay, there are a few authorized list of deductions. One is absence from duty. Okay, so if the employee or the worker remains absent without any prior information, they can deduct from the wages. Okay, and deduction for damage or loss. Okay, if the worker creates any damage or loss, the amount of loss can be deducted from the wages, provided it has got the approval from the prior approval from the authority. Okay. And deduction for recovery of advance or loans. Okay, if the company is offering any loans or advance salary advances, that can be deducted from the wage of the workers or the employees, provided there are few conditions which you have to adhere to. Okay, so within the specified timelines, the loans has to be recovered, and the what is the interest rate for the loans. All this has been clear-cutly, I mean, it has been mentioned clear-cut in the code. Okay, so the employer has to adhere to all these norms before offering any loans or advances to the workers. Okay. And fines. And before slapping or before leaving any fines on employee, the establishment has to list down the list of acts or omissions, means like for these kind of activity or indisciplined behavior, the fine is levied against that particular employee. Okay, so this list has to be prepared, and it should be, I mean, the approval has to be, I mean, the employer has to get the approval from the appropriate authority before levying these fines. Okay, and before doing that fine, levying the fine for the employee, an opportunity has to be given to the particular employee to express like what has exactly happened. Okay, so without which they cannot directly go on slap fine on the employee. And in case if they are providing any amenities, like for example house accommodation, means they can deduct from the salary, provided the value should be justifiable. Okay, and moreover, all these list of deductions, it should not go beyond 50% of the wages for that specific wage period. And payment of bonus. So the statutory payment of bonus has to be made to the employees, provided they meet out the threshold limit. Okay, so if the employee is eligible as per the threshold limit notified by the appropriate state government, the employer has to pay the bonus. Okay, the minimum bonus is 8.33 and maximum is 20%. So to have this bonus, they have to at least work for 30 days for the particular accounting year period. So coming to social security. So social security is the laws which relates to the which provides for the social security benefits for the all type of workers, both from organized and unorganized sector. Okay, so it provides benefits for all the employees and the workers which belong to both the sectors. So we have the employee provident fund, we have that employee provident fund scheme, pension scheme, employee deposit linked insurance, and this is applicable for establishments having 20 or more employees in their establishment, in a preceding 12 months period. If at any point one day, if they have a 24 or more employees, means the act remains applicable. If the number of headcount goes below 20, the act still remains, sorry, not the act, the provision still remains applicable for that particular establishment. Okay, earlier it was this applicability was a specific list of scheduled employments, but now it is not so. It is applicable for all type of employments. Okay, employee state insurance. So this employee state insurance is applicable for all the establishments having 10 or more employees. Okay. And in case if the factory or the establishment is having a very hazardous kind of activity, means even if one employee is there, the provision is very much applicable to that particular establishment. Okay. And moreover, this is applicable across all the across India. Means earlier the ESI used to notify that this area is being covered, a remote area in Maharashtra or remote area in Tamil Nadu. They will notify that the districts which falling under the what do you say that, for example, Tirunelveli, Kanyakumari, means they will notify that these remote rural areas is covered under the ESI. But right now it is not so. Across India, wherever the employee or the worker is working, the establishments in that area, it has to be covered under the ESI. Okay. And they have gone in for redefinition of the family. Okay, especially female employees, if they have any dependent father-in-law and mother-in-law, that is being classified as they have brought in under the definition of a family. Okay, so any female employees who have a dependent father-in-law or mother-in-law, means they are being covered as a family. Okay. And moreover, while bringing the definition or including the father-in-law and mother-in-law, means they have to see that it doesn't go that the what do you say that they don't exceed the income limit as notified by the government. Okay, so to make sure that before including mother-in-law and father-in-law, the total income that should not increase the prescribed limit as per the notification by the government. Okay. The rest other benefits like medical benefit, cash benefit, sickness benefit, whatever that is being currently available to the worker, that is very much available in the current labor code provisions also. Gratuity. So gratuity is paid at the time of termination, superannuation, retirement, or resignation. Sorry, at the time of resignation, or in case of death or disablement due to accident. Okay, so in all these circumstances, the gratuity is payable to the employee. Okay, so to avail this benefit, there are few conditions which the employee has to meet out. One is the IOs of continuous service is very much eligible. The employee should have that. Okay, and in case of fixed term employee, if the contract gets expired after 1 year of continuous service, means the the fixed term employee is very much eligible for the gratuity. Okay, so calculation, there is no change in the calculation, except in earlier it is a last round basic, but here it is from the wages. Okay, so the last round wages. So accordingly, we have to calculate the gratuity benefit, and that has to be paid to the employee. This is effective right from 21st of November 2025. Okay. And moreover, the gratuity can be paid within 30 days from the last date of working of the employee. Okay. So once the employee joins the organization, once he completes 1 year of service, it is mandatory, it is the responsibility of the employer to collect the nomination details from the employee. Okay, they have to collect the legal hire. For suppose in case if anything happens, means how the amount can be settled to whom, like legal hire. Okay, all these details will be captured in the nomination. Maternity benefit. So not much difference except for the maternity amount, wherein they have to go pay the benefit as per the redefined wage structure. Okay, so to have this benefit, the female employee should have completed at least 80 days of work in the preceding 12 months period before availing the service. The benefit period, as you are aware of it, around 6 weeks, 8 weeks before the expected date of delivery, and rest after the delivery. And in case of miscarriage or termination, 6 weeks benefit period, and for tubectomy, 2 weeks period. Okay. And employer, in case if they are not providing any prenatal or postnatal care, means they have to provide medical bonus of rupees 3,500. Okay. And if they provide service, means prenatal postnatal care, means they don't have to provide this medical bonus. And once the female employee resumes the work, they have to provide nursing breaks for that female employee. Okay, so 2 nursing breaks has to be provided in addition to the rest intervals. Okay. And they have to provide crutch facility for the female employees, not for female employees. Okay, it says about persons or the employees, irrespective of the gender. If 50 or more employees are there, a crutch facility has to be provided by the employer. Okay, so either it can be their own crutch facility or they can have a common crutch facility wherein 2 or more employees they can join together and have a common crutch facilities. Okay, so during this maternity benefit period, okay, the employer they cannot take any legal action. Okay, that legal action resulting in the dismissal or discharge of the particular employee. Okay, this is not at all permissible under this maternity benefit provisions. Okay. Employee compensation. So you see, normally if any accident happens at the workplace, okay, so this accident may happen either while at the workplace or while commuting to the workplace, back and forth, either while on traveling towards to the workplace or coming back from the workplace. Any accident happens, it is being covered under the employee compensation. Okay, so based on the nature of the injury or in case if it death means the compensation amount will differ. Okay. So in case of death of employee wherein the legal hire is minor means the amount of compensation has to be deposited to the respective authority as per the jurisdiction limit. Okay. This social security code, no, it is being extended widely. It is being extended widely to all the unorganized sectors like gig workers and other unorganized sector workers also. So it ensures that all the aggregators means the platform owners. Okay, so those who connect between, those who act as a bridge between the service provider and the service who avail the service. Okay, so they are the aggregators. They have to pay a social security fund of 1 to 2% with a maximum of 5% cap from their profit. Okay, so this fund directly goes to the social security fund for the gig workers. Okay. So building and other construction workers. So here, this act is applicable if 10 or more building and construction workers is being engaged. Okay. So if 10 or more building workers is being engaged means this act becomes applicable. What happens? The employer has to contribute 1 to 2% of a cess amount fee. Okay. So this cess amount is nothing but the total construction cost. From the total construction cost, 1 to 2% of the amount is being paid as assess to the government. Okay, so in case if the construction cost is below 50 lakhs, okay, this applicability of this BOCW is not applicable. And in case if it is the construction work happens within the factory premises or in mine means, this provision of BOCW is not applicable. Okay, so being as an individual, if I am an individual, if I am investing more than 50 lakhs or means if I am engaging 10 or more BOCW workers, means as an individual, I have to pay assess amount to the government of the total construction cost. Okay, so before the completion of the after the completion of the construction, if there is any due in the cess means that has to be paid to the government within 60 days. Employment exchange or career centers. Here we have this, currently we have that employment exchange notification. Okay, so similarly under this code, the employer has to notify any vacancies which they have in their organization before posting it or before going in for any recruitment. They have to ensure that they are notifying the authorized career centers or the websites which the government they have. So they have to notify the vacancies in the prescribed manner before recruiting or before filling the vacancies. Okay, so it is not mandatory that they have to select the candidate from the portal or through the authorized career centers. Okay, so the thing is mandatorily they have to notify the career centers in the prescribed format, and although and so on, and they also have to file the returns on periodically. Okay, so these are all the minimum compliance under this employment exchange notification. So coming to code on occupational safety, health and working conditions. So here this code is mainly focusing on the health, the safety of the work and the working conditions of the workers in the factories and the BDC mines and plantations, and even in other establishments, we're having a workforce of 10 to more workers. Okay. So here, if the establishment is having a 10 or more workers, they have to go for a registration. Okay. If they have any existing registrations, that is more than enough, provided it is valid. Okay. So if it is not valid, they have to go for registration under this as per the code, and they have to renew it periodically. Okay. So this can be done through online. They have to pay they have to submit the application, pay the prescribed fees, and get this registration done through portal. Okay. And moreover, people who are registering the employer who is registration, going for registration under the provisions of the contract labor, they have to notify to the authority about the commencement and the completion of the operations of the contract work. This code lists down few of the employer obligations. One is issuing appointment letter. Who are being recruited, they have to be provided with a appointment letter. Okay? An annual health examination. This should be free of cost. See, we have to look out for the appropriate state government rules for this. Okay. See, for example, if you take in Karnataka, it specifically mentions only for the workers from the factories, mines, and the plantation. Okay. So it specifically says that workers who are working in the factories and mines and plantations, they have to be subjected for annual health examination once in a year. And it is the employer's accountability to provide adequate safety measures at the workplace, so that any the worker is being protected from any occupational hazards. Okay. And safety committee. Okay, so if there is, based on the notification from the appropriate state government, a safety committee shall be formed by the establishment. This safety committee should have equal representation from the employee and the employer. Okay, equal representation should be there. So what is the motive of having the safety committees? They will discuss all the issues which comes across regarding to the safety of the employee or the worker at the workplace. Okay, they will discuss what are the pros and cons in reference to the safety, and they will take appropriate measures to ensure that adequate safety measures is being provided to the worker. And if any accidents happens, they will take precautionary measures, they take preventive measures so that the accident doesn't reoccur. Okay. So this is one the employer has to comply with. Okay. Second is they have to appoint safety officers. Okay, especially factories with 500 more workers, a safety officer has to be appointed. Okay, and coming to BOCW, building and other construction, if they have 250 or more workers, a safety officer. If it is a hazardous nature of activity, means if they have a 250 or more workers, they have to have one safety officers. And in case of mine, if 100 or more workers are there, a safety officer should be appointed. Okay, if it is going beyond a prescribed limits, means they can appoint more than one safety officer. So while appointing the safety officer, they have to follow that norms that has been prescribed. What is the educational qualification, the number of years of experience, and that to which type of experience they should have. All the prescribed norms has to be complied with while recruiting the safety officer. Providing safety, health, and welfare facilities at the workplace. It is the prime responsibility of the employer to provide all these are very basic, essential facilities which the employer has to provide with, so that the employer feels the employee or the worker, they feel safe at the workplace. One is portable drinking water. Okay, adequate portable drinking water, which is very much accessible at the workplace, that has to be provided. And the workplace should be adequately lighting facility and ventilation facility has to be provided. Okay, and moreover, it has to be the cleanliness has to be maintained. It should be hygiene. Okay, and they to make sure that they don't contract any disease from the workplace. And toilet facilities. I mean, they have to provide toilet facilities, sufficient toilet facilities for all the genders. When we say all the genders, the third gender inclusive of the third gender also. And in case if that particular nature of employment requires a bathing and a washing facility has to be required, means the adequate facility has to be provided by the employer. Okay, so when we say all these facilities, it is include for the contract labors also. So they have to provide sufficient facility for the contract labors also, and the first aid facility, and if the restrooms also has to be provided for all the genders. And if they have more than 100 workers, means they have to have a canteen facility inside the premises. And they should not stand for a long period of time. They have to have a sitting facility also. Okay. And ambulance room is mandatory for where 500 or more workers are there in mine and BOCW. Okay. They have given a set of prescribed conditions, like it should be under the control of a doctor, a nurse, and they have to have all the medical facilities inside that ambulance room. Before taking it, they have to provide the first aid facility inside the ambulance room, and before taking it to any hospital. So these are all prescribed norms which the employer has to follow to have this ambulance room. Okay. So as we discussed in the maternity benefit, a crèche facilities mandatorily has to be provided by the employer if they have a 50 or more workers. When we say 50 or more workers, we have to consider the contract labors also. So these are all the list of records and returns which an employer has to maintain. One is register of employees, attendance muster roll. You can say that even under the wage code also we are maintaining the same register. Do we have to duplicate the registers? So based on you can just inform the authority, you can get the permission. You don't have to duplicate the records. Okay, you can maintain instead under the one act or one code. Okay? And register of wages and overtime deductions, register of dangerous occurrences, wage slip, and annual returns. All this you can do it electronically. You don't have to maintain manually. So if there is any accident happens at the workplace, okay, either it may result in injury or it can result in the death of the employees. In that case, employer is very much accountable that he informs the authority within the timeline. Okay, for example, within 12 hours of period, the employer has to inform the authority in the respective jurisdiction. Okay, so that conditions they have to follow, and there is a prescribed format with which the employer has to notify to the authority. Okay, in case of death, he has to inform the more number of authorities, which includes the magistrate, the district collector also, and they have to inform the family members. So these are all the few things which the employer has to adhere to in case if there is any workplace accident happens which results in the injury or death. Okay, in some case, if the worker or the employee doesn't return back to the work within 48 hours of period, means that has to be informed to the authority. See, it's like a sequence of events which happens after the accidents that has to be updated to the authority within the prescribed timeline. Okay, so that has to be updated to the authority if the worker doesn't returns after the accident within 48 hours of period. And in some cases, they may don't, what do you say, that they don't have the disability at the time of injury. The injury may not result in a disablement, okay? But subsequently, after a few days period, they may fall into a disability, like maybe a partial disability, or it can be a permanent disability also. So in that case, the employer has to inform the authority within the prescribed timelines, okay? And the code has listed down few dangerous activities. Okay, so they have listed down specifically that these kind of bursting or handling of chemicals or any subsequent to that any inflammable materials if they have, as because of handling those chemicals or as because of having the process, if anything happens, a dangerous thing happens, means the employee is liable to inform the authority and take appropriate actions. Okay, there is a prescribed registers or the norms or the forms which they have to inform to the authority within the timeline. Okay, and moreover, at the workplace, if the if the worker contracts any disease, okay, they have mentioned clearly in the third schedule. They have listed down few occupational diseases which if the worker contracts at the time of employment, that has to be informed to the authority within the timeline. Okay. So engaging women at the night shift. Okay. So when you engage as an employer, when the female employees is being engaged at the night, during night, when we say night means before 6 a.m. and after 7 p.m. This is what the code defines as a night. Okay. So if any female employees who are being engaged after 7 p.m. and before 6 a.m., we have to provide, as an employer, we have to provide adequate safety measures to the female employees. Okay. And moreover, they have to take the consent from the female employees before engaging them during this time period. And if in case, as the code has given equal opportunity and for all the genders, okay, so in case if we are engaging any female employees in a very dangerous occupations, means it is the prime responsibility of the employer to provide adequate safeguard measures. Okay, see, for example, in any dangerous machines, means they have to give the protection, they have to safeguard that safety guard should be there while handling those machineries. Okay, so this code has given the list of dangerous occupations and the dangerous operations, what kind of safety adequate measures that has to be implemented. All this has been detailed out in this OSHW code. Okay, so that the employer has to adhere to. And in case if any female employees in the in the maternity period, means they should not be engaged in any manufacturing process or operations which is very risky for their health. Okay, and which pose any risk for the fetal development, that should not be followed. Okay, it has been totally banned. Actually, we cannot engage the pregnant female employees in the dangerous operations. Okay. So contract labor. So this code provides for the contract labor provision. So all those establishments who is having, which are having 50 or more employees, or the contract laborers, means they have to go for registration under the contract labor provisions. And similarly, a contractor who is having a 50 or more contract laborers, means they also have to have a license. Okay. So a single license is more sufficient. For example, if a contractor is providing service to the same employer at different locations, more than one state, means a single license is more than sufficient. They don't have to go for a multiple license. Okay, the code provides for a single license is more than enough to operate in multiple locations. Okay, and the principal employer is very much accountable for providing the welfare facilities of the contract laborers. So as we discussed in the earlier slide, what are the welfare facilities? It is ultimately the principal employer is accountable for providing all those facilities to the contract laborers. Okay, and in case if the contractor fails to pay the wage on time, it is the principal employer's accountability to provide the payment. Okay, so it is not only restricting to the payment, it also extends to the bonus, gratuity also. So it is the prime responsibility of the principal employer to make sure that the contractor is making the payment to the contract labor on time. So interstate migrant workmen. So if there is 10 or more interstate migrant workers are being engaged by the employer, this provision is very much applicable. They have to go in for registrations and they have to provide journey allowance to the workers, okay, to and fro. Okay, so when we say there is a what do you say, that a threshold limit is being fixed to understand whether the worker is being considered as an interstate migrant, a salary of 18,000. If they are drawing a wage of 18,000, means up to 18,000, means they are being considered as an interest, and they are coming from other states for working in other state, means they are being considered as an interstate migrant workman. And to and fro journey allowance shall be provided by the employer once in a year. Okay, so when we say interstate migrant worker, it is very much applicable both for the direct and in the indirect workers, means people who are the contract laborers also, if they fall under the purview of this eligible limits, they are also being considered as an interstate migrant workman, and the providing benefits is in under the liability of the principal employer. They have to ensure that the contractor provides this benefit to the contract labor too. Okay. So finally, we are coming to this Code on Industrial Relations. Code on Industrial Relations, it speaks about how a trade union can be formed, how the trade union members can be selected either through employees election or through representation, whatever may be the means. It has given the detail how a trade union can be formed and how the employer can recognize a trade union in their establishment, and or the conditions of employment in the industrial establishment setup, and how an industrial, if any industrial disputes happens, means how this can be resolved with the different machineries. Okay, so all these you can find in this under the Industrial Relations Code. Bipartite committees. So we have two different committees under this Industrial Relations Code. One is Works Committee and Grievance Redressal Committee. So Works Committee, wherever the establishment is having 100 or more workers, this Works Committee has to be formed. Okay, this should have an equal representation from the employer and the worker sides also. Okay, so here the workers they can choose their representatives in the prescribed manner as per the notification by the appropriate state government. Or they have to adhere to the notification given by the appropriate state government. Okay. So what is the objective of having this works committee? So mainly their objective is to maintain a harmonious relationship between the employer and the worker. So that is the prime focus of having this works committee. Okay. So grievance redressal committee, wherever if you find an establishment having 20 or more workers, this grievance redressal committee has to be formed. Okay. So here again the representation should be equal both from the employer side and the employee side. This should be led by a chairperson. This can be either from the employee side or from the employer side also. See, I'm using this term employee, sorry. It is worker, okay, worker side, okay, worker representative. So either it can be from the worker side also, or it can be from the employer side, but it should be on the rotation basis, okay. So even women employees, women workers, okay, they should be given an adequate representation in the grievance redressal committee, so that whatever the any act which falls under the POSH definition, that also can be addressed through this. They can also bring out all these issues in this grievance redressal committee. Okay? So any aggrieved employees, they have to submit an application to this committee within a prescribed timeline. Okay, so this is allowed for a maximum of 1 year of period from the date of incident. So within which they can submit the application. So once they submit the application, the committee has to resolve this dispute within 30 days period. Okay. And in case if you have more number of workers in the establishments, means more than one committee can be formed to address this issue. So this is called as bipartite committees. One is works committee, another one is grievance redressal committee. This is to bring out any industrial disputes. Means this can be resolved at this stage itself to bring a harmonious relationship between the employer and the worker. Standing order. So if an establishment is having 300 or more workers, means the standing order is very much applicable. Okay, so the employer can make use of the model standing order, which is very much available under the code, and they can just simply intimate to the certifying officer of that particular jurisdiction about this model standing order which they follow. Okay, this simple intimation of the standing order to the specified authority is more than enough. In case if the employer goes for the models draft standing order which they create on their own as per the prescribed conditions, means they have to obtain the approval from the authority. So they have to get this standing order registered and approved from the authority, and it has to be displayed in the work premises. Okay, so before getting that approval, they have to make sure that whoever the representatives from the workers, it can be in the form of a trade union or it can be form of a negotiating council. The employer has to take consent from the trade unions or the negotiating council before submitting it the draft for the approval from the authority. So all these things they can do through electronic mode. So layoff, retrenchment, and closure. Okay, so when you take any industrial establishment, all these are part and parcel of the establishment. Okay, so if they have a 50 or a 50 to up to 299 workers, means what is the conditions they have to follow? Suppose in case if the organization decides to lay off, means they have to pay 50% of basic and DA, and they have to give a month notice to the particular worker before going in for layoff. Okay. And in case of retrenchment, if the establishment decides to retrench the employee, means the worker, means they have to give 1 month notice period. Along with that, they have to give 15 days of average wage for each completed years of service at the time of retrenchment. And along with that, a reskilling fund also has to be paid to that particular worker. So how this reskilling fund is being calculated is they have to calculate the 15 days of average wage for that particular worker, and that has to be contributed through bank transaction. It has to be forwarded to the specified authority. Okay, through authority, this amount goes to the worker. So this is called reskilling fund. And in case if the establishment decides to close the establishment, means they have to notify, they have to serve the notice to the both the workers and the authority 60 days before. Okay, and in case if there is a change or a transfer of ownership, means the workers who have completed a year of service, they have to be notified in prior, and they have to be provided with the retrenchment compensation. Okay, so all these timelines, the 60 days, 1 month, all these are only for the establishment which is having a workforce between 50 to 299. Okay, in case if the workforce goes beyond 300, means they have to adhere to different timelines. For example, if they go for a retrenchment, means a 3 months notice period has to be given. Okay, and in case of closure of establishments, 90 days before, the employer has to notify to the respective authorities and the workers. So notice of strike and lockout. Okay, so in case if the employer is receiving any intimation from the workers' representative stating that they are going for a strike, means that notification has to be served to the appropriate authority and the conciliation officers before 5 days period. Okay, so they have to give that notice to the specified authorities within 5 days period. And in case of lockout, if the employer decides to go for a lockout, means that also has to be intimated to the respective authorities within 5 days period. So this is the industrial relations. So we were speaking about the trade unions and negotiating council. Of course, the employer has to recognize the trade unions if they have more than 50% of representation from the worker side. If it is less than 50% of workers representation, means if they have a part of more than one union, means they can form a negotiating union, or you can say negotiating council, wherein they can give a representation of 20%, 20% from each negotiating trade unions, and they form a negotiating council. So this is what the Industrial Relations Code speaks about. Okay. So as I told you at the beginning of this session, see, this is the compliance handbook that has been given by the Ministry of Labor and Employment. Okay, this is a handy book for the employer to understand. But to have more details, we need to understand the appropriate state government notification. So, Relativity, as a compliance expert, right now we are providing compliance consultation for the labor code implementation. So as I told you, based on the appropriate state government notification, the labor code implementation differs. So we do offer services in the labor code implementation. What we do is we study the existing practice, and in the organization, we identify the gaps wherever the organization is lagging behind in the labor code as per the labor code provisions. We recommend, we advise them, we advise on the few things, like for example, like HR policies, or appointment order, a few statutory documents which they have to go for a change. All these things we recommend after having a complete, it's like a customized service actually, based on the nature of the location of the organization and the number of workforce they have. The labor code implementation differs as per the different types of, even the different types of organization setup also, the implementation differs. So right now, Relativity is providing this labor code implementation to all type of organizations. I request all the participants to make use of this service from Relativity. So how we do this service means, like we have a roadmap. Okay, for the initial 2 weeks, we assess the performance. I mean, we assess the gap actually, where the organizations lag behind the labor code implementations. Like we study the current existing practice that the organization follows, and what is required under the labor code. Okay, so that gap analysis, we do it for a period of 2 weeks, provided the establishment, they have to provide all the required set of information, the data they have to share. So once we thoroughly analyze all those data, and we analyze and we arrive at a gap analysis. Okay, so where they lag behind, what, and the next comes is we go for the recommendation. See, for example, if the payroll structure is not as per the labor code, means we will suggest that we'll recommend that we have to change the payroll structure. Okay, and we go for the if any agreement is there, like for example, contract labor agreement, or if they have any freelancers or the fixed term employees, means we go for a study of the contract agreement and we recommend if any changes is required. And as per OSHW, there are few compliance as a principal employer towards the direct employees, and the contract labor is also very much required. For we saw that night shift engagement of female employees, wherein we have to adhere to few terms and conditions. So in that case, as an employer, we have to have a policy of engaging female employees in the night shift and even for the overtime also. So, and what are the safety measures as an employer we have to provide. So all this is being analyzed at the period between 7 to 8 weeks of time. Okay. And finally, the final implementation is the 11th to 12th week. What we do is we'll analyze who are all the stakeholders to implement all these changes. We recommend that all these stakeholders has to be provided with the sufficient training to implement this labor code. Okay. So this is how we make sure that our existing clients and people who are seeking support for the labor code implementation, we go for this feedback. So I request all the participants to have a feedback about this session. And please, you can post your questions subsequently. So if you have any questions, please post your questions in the chat box. We'll address it. And if you want to avail services from Relativity, please, you can inquire with the specified in the mentioned mail ID, what is your exact requirement in reference to the latest labor code. So we are here to support. We'll just, if you want to know more details about this labor code implementation, please get in touch with the specified mail ID and the mobile number we have given. I request all the participants to participate in this poll. This will give us a useful feedback for us to have a subsequent sessions. Okay.
Parallel, you can take up the question from the chat
Yeah,
box.
please. Yeah. Okay, so you can get connected with us in all the social platforms. Fine. Okay, so can I have a look at the, oh yeah. Requesting you to speak. Okay, fine, sorry. So for this question is from Vinod Kumar. For technical company, they need to do technical audit or clearance approval required to process F&F. Unfortunately, it may not be possible in 2 days. Okay. See, this we have to study. I don't know what is that you are referring to, technical company. Okay. See, irrespective of the nature of the establishment, the Act says that whoever is being, what do you say, that for what reason they are being sent out, it may be voluntary or involuntarily, from the last working days, 2 days, within 2 days, it has to be paid. Okay. So we need to work out the procedure, how fast you can settle the wage is due. Okay. That has to be studied individually for customized, mean for each organization. So you can come out, you can take the support from us. You can get in touch with us. Okay. What is this wage code? This is from MBA Babu. What is this wage code name, madam? Wage code, code on wages. Yeah, thank you, Edwin. Insightful. What about Maharashtra? So, can you be more specific about your question? What about Maharashtra? Edwin, will be happy to connect. Yeah, please, you can get it connect. From Ponnamma, grievance redressal committee is not required if there are no workers or more than 20, is what I noted. So if it's employees, not workers as per the definition, then what is the required measures to be done by the employee? See, the Act says that worker, okay, it clearly says that if you have 20 or more worker, you have to have a grievance redressal committee. Okay. If other than the worker, if you have a grievance for the employees, means you can have your own redressal machineries. Okay, you can have your own policy to address those issues. Yeah, you can take the video recording. So this is from Nikhil Kumar. Ma'am, thank you. Okay, scheduling this. It is truly going to be okay, helpful for, yeah, thank you so much. like us who are okay, fine. Is gratuity mandatory for startups that have around 50 to 60 employees? We are an IT company and currently do not have a gratuity policy in place for our employees. See, the Act doesn't discriminate between whether startups are more than 1 year or 5 year or old. It's not like that, okay? It says that any establishment. So we have to comply with that provisions. I think I have addressed it twice. You have asked. Okay, fine. Anand Hegde, is there any update on state rules on new codes? See, we are looking for the final notification from the central government also and from the state government also. So once that is being notified, obviously we'll be having a session on that also to explain. Okay, and Akshay, from which date should this be compulsorily implemented in Maharashtra or any other state? I think you are asking for the ESA, if I'm correct. Yes, from the date of notification, it has to be, the ESA coverage has to be given, okay? So I think, I assume that this is in reference to the ESA notification, okay? Okay, this is again from Nikhil. I think I have addressed this question. Is gratuity mandatory for startups of 50 to 60 employees? Yes, it is. Naresh, is a retired employee gets ESI benefits after retirement? No, not possible. This is from Usha. All the points discussed in this webinar is applicable to factories and companies who have more than 50 workers. See, this has to be seen, okay, depending on the provisions. For example, as I told you, Karnataka industrial establishment, they are, for annual examination, they are simply referring to industrial establishment as factories, BDC gas and plantation as a industrial establishments. Nowhere they are referring to as any establishment, okay, means like other than IT or ITES. So in that case, we have to take it. So we have to go by the appropriate state government notifications to understand whether the provision is applicable for the factories or other establishments. Okay, this is from Sanjay. Is it mandatory for a company to provide uniforms to all the manufacturing? No, Act doesn't say, but you have to provide safety measures. Okay, so if that particular nature of work requires any safety gears, means it is the principal employee's accountability to provide that safety gears. It may be in the form of a court also. Okay, in that case, it's the principal employee's liability. Shrikant Mane, what will be the ESIC wage ceiling as per the new wage code on wage, please? Please, you have to go for a revision of the wage code as per the wage code recommendation. Yeah. Thank you, Purnama. And GVS, under the code on social security, wage code interpretation 2025 onwards, ESIC applicability is linked to wage is equal to basic plus DA. Is it implemented in process to implement requesting? See, the ESI has given a notification and subsequently they have withdrawn that, but that is one advice. But as per the labor code, wage code requirement, you have to redefine your wages. So once you redefine the wages, we have to understand the eligibility threshold of the particular worker. If the worker is eligible for the ESI means we have to provide for the ESI. Again, this is from Babu. Yes, good afternoon. Having 50 employees, crutch is mandatory. Yes, obviously, crutch is mandatory. Naresh, as per new labor code regarding gratuity, the calculations are based on wages instead of basic pay. Okay, what if the employees are 8 years in service? Is 50% wage-based gratuity applicable from now? But see, obviously, people who have left the organization from 21st of November 2025, they are very much eligible to have gratuity based on the revised wage structure. Okay, Akshay. I'm asking for the new wage code implementation. From which date should the new wage code should be compulsory? Yes, right from 21st of November 2025, it is very much applicable. Anand Hegde, whether layoff, retrenchment, and closure regulations are applicable for non-industrial establishments. As in, yes, please, obviously, see that as I told you, this handbook, it refers to only for the factories or the BDC gas establishments, okay? But please, we have to refer to the appropriate state government notifications. We have to look out. As I told you, I gave an example for the Karnataka Industrial Relations, under which the OSH code, under which the annual examination, they are specifically mentioned for the factories and BDC gas and not for any other establishments, okay? And this is from Sri Sailam. Okay, we have hired 5 to 10 interns for a period of 3 to 6 months. How should we process their payments? On what basis should we pay them? Should we ask them to raise invoices, and do we please get in connect with our team? They will help you out. This is something which we have to address this in a customized way. Okay, we may need some records also. Please get in touch with the team. Sanjay Srivas, whenever workers get transferred from one plant to another plant in another state, do you need to revise these agreements to new state requirements? Yes, we have to see that, because we have to adhere to the appropriate state minimum rate to notification. So we have to adhere to that. So we have to revise the agreement. Okay. Shrisha, I am from Mumbai and have few questions. Is the bonus as mentioned 8.33% minimum up to 20 and my maximum up to 20% applicable to factory establishment? As per Factory Act, it is 7,000. Can you get? Yes, please. You have to wait for the notification from the appropriate state government. Okay. So this is the 7,000 is the current practice. Okay. Now the empowerment is given to the state government. We have to wait for the notification from the appropriate state government. Okay. Second question is gratuity. Is it compulsory to calculate from last monthly wage and not from basic? When yes, exactly, we have to calculate from the last drawn wages, not from the basic. If we have POSH committee, then can the same committee member of the be member of the other committee which is formed? Yeah, you can have in the grievance committee also. No, the act doesn't restrict actually. GVS, apart from apart from Form 3, now shop and establishment tax as forms while registering. Is it right that Form Y is implemented from the new wage? This is, you're referring to which state particularly? This question has to be very clear. Okay, so you see, Shop Act is different. Okay, it is a state act. Okay, it is very much applicable currently. It is not repealed. Okay, you have to follow, if your establishment is being registered in the Shop Act, you have to follow the Shop Act compliance. Okay, you cannot ignore it. Whereas the wage code also, or the labor code also, is defining few implementation wherein you have to implement the wage code, the labor code norms also. Okay, so thank you all. Thank you.
So
Shall
thank
we
you everyone
close?
for joining the session. Let's meet next month. Thank you.
Thank you all.